Good morning, my name is Bruce Provan. I'm the Managing Director of Page Provan, Family and Fertility Lawyers, a firm of lawyers that practices in central Brisbane exclusively in family and fertility law. I want to talk to you this morning about whether collaborative law works in family law in Australia. The short answer is yes, it does, and it can. Now, just to explain what collaborative law is, it's a process that began in the United States about 30 or 40 years ago now, where both clients and their lawyers wanted to explore a better way of resolving their matters, both parenting and property matters, following a separation, rather than go through the expense and stress of going through court proceedings. So this idea of collaborative law was developed, and it became set up in Australia about 20 years ago. And the idea of collaborative law is that it's a cooperative and respectful process which parties negotiate their property settlement without going through court. And the way it works is that certain lawyers, including myself, are trained as collaborative lawyers and understand the process. And it often involves a series of meetings between the parties and their lawyers, and sometimes other professionals, to try to negotiate an arrangement for the division of their property or arrangements for the children. Now, that process can also involve other professionals such as accountants, counsellors, financial advisors, or sometimes even what they call divorce coaches, and that is people who assist the parties through that process. Now, the deal is with lawyers is that if the matter's not resolved through negotiations as part of that collaborative law process and has to go to court, both of the lawyers have to bow out, and the parties would then engage other lawyers. And the reason for that is that if lawyers know they're not going to be engaged for any litigation, it gives them more incentive to really help the parties to try and negotiate an agreement. Now, collaborative law hasn't taken off in a big way in Australia like it has in the United States. And part of that, in Brisbane at least, is that so many matters, especially property settlement matters, are resolved through mediation. So the assistance from a mediator who is an independent person who assists people in their negotiation can often lead to matters being resolved as an alternative to the collaborative law process. The other thing that I often say to clients is that even of the cases that start in court, only 5% of them will proceed to a hearing in court. 95% of them will settle along the way, and often that's with the assistance of a mediation or other alternative dispute resolution processes. So there are a number of lawyers in Australia who are trained as collaborative professionals, and I'm aware that there's been a number of successful cases where parties have gone through the process and been able to reach an agreement, and then been able to document the agreement in terms of court orders or a binding financial agreement or in other ways. So yes, certainly collaborative law can work in family law, but it's not always the best option. And part of our role as a family lawyer is to discuss all of the options with our clients and advise them about the pros and cons of each process to decide what is the right process for that client, and then seek the cooperation of their former partner or spouse to engage in that process. I'm Bruce Provan from Page Provan, Family and Fertility Lawyers.